Welcome to week 1 of legal drafting. This week we'll be looking at some foundational principles just to get us started with being able to draft legal documents. We will of course be working our way towards drafting complex documents like pleadings such as statements of claim and defences, affidavits, wills, letters to clients, outlines of argument, etc. But this week we just thought we'd start off with a basic introduction to some principles that you may already know or may have subconsciously acquired through the process of reading legal documents, cases, etc. So today we're going to look at 4 questions that you should always ask yourself prior to commencing the drafting process. And then we will look at some very basic concepts such as ensuring that you identify the foundational information at the beginning of the document and group related items together. We'll also talk about the importance of using definitions. We will also look at clarity in terms of stipulating time periods within which something must be completed or when action is required by a particular due date, because this can be quite controversial when it comes to interpreting things like contracts, as well as where you request people to do something by way of letter, for example. And finally, we will talk about lists. Lists can be very useful in the drafting process because they can convey information in a short, effective manner to the reader, but they can also be problematic when the content in the list does not match the header that leads into that list.
This week we will also consider the principles of plain English drafting, which focus on precision and expressing information in a concise manner.
So what are some key considerations when drafting a legal document? Well, as the study guide notes, there are 4 questions that you should ask yourself before you commence the drafting process. And this really is something that you should do regardless of the document type. It may be that not all 4 are relevant, but if you start off with 4 and then work out which ones are relevant, you will always make sure that you cover you tick all of the boxes that you need to.
Now you will see this list appear frequently throughout the study guides because the first 3 questions, and in fact usually the 4th as well, are relevant to almost all drafting tasks. It's crucial you address the first question because this will dictate the structure, the format, and the length of the document. It will also affect the expression too. A document that is intended to be persuasive, like an outline of argument, is a very different beast to a letter that merely requests information from a third party like the bank. The reader of the document is equally important. If the reader is a layperson, they are unlikely to understand the nuances of the law and their case, so they will need you to provide sufficient context and explanations so that they can understand your point. In contrast, when you're writing a letter to other members of the legal profession, you can assume that they've got a working knowledge of the relevant law, the court procedures, and the rules of evidence. Now we will explore these 4 questions in further detail as we work through the various legal documents over the course of the term.
One of the key drafting principles is to identify foundational information first. So if you were drafting an affidavit, it would be to identify who is the person that is swearing the affidavit, on whose behalf are they making that statement, and what is their relationship to the legal dispute. In relation to a contract, you would be looking at, for example, if it's a contract for the sale of goods, focusing on who the parties are, what goods are to be supplied, and what payment is to be provided for those goods. In other words, you're grouping the basic information together at the outset of the document. There's no point in setting out a term about delivery at the beginning before you've even identified what will be supplied and by whom. So you need to think about the basic information that's relevant to the particular drafting task and also the legal relationship between the parties. So where you're drafting a trust deed, for example, you would want to think about the basic components of a trust, which are a trustee who holds property for the benefit of one or more beneficiaries. So you would need to identify who the trustee is, who the beneficiaries are, and what comprises the trust property. Then you need to think about the specific detail of each of those things. So for example, if there's more than one beneficiary, do they have an equal interest in the property, or does one get 20% and the other gets 80%? So once you've got the basic or foundational information, you can then start to think about specifics. And you can also then start to think about more complicated provisions, such as what happens if the trustee wants to sell the trust property. Note also that some of the information may be assumed by the parties in that it goes without saying for them. An example might be an implied term that the premises would be fit for habitation, but it's your job as a lawyer to identify all the relevant and likely issues that may arise in the future and then cater for them in the draft. Now, you may recall from statutory interpretation that when you're engaging in reading a statute, you should always go to the definitions to see if any of the words you have identified as potentially ambiguous or requiring interpretation have been defined in the definition section. And the same is true in relation to legal documents, contracts, trust deeds, partnership deeds, deeds of termination, joint venture agreements, loan documentation, leases, the list could go on forever. They all generally include definition sections. The great thing about definitions is that a single word or a short phrase can represent a lot of words, and that removes clutter from the provision and makes the provision easier for everyone to read. If there's a risk that a word or a phrase might be open to different interpretations, it's a really good idea to define it and provide some clarity for the parties. So it's really important as part of your initial planning process that you consider whether or not to use definitions and whether or not it's necessary for them to be there to provide more certainty as to the meaning of the words being used, or whether it would help declutter the relevant provision and make it easier to read. Now, everybody knows that lawyers are pedantic, so it's no surprise that you need to focus your attention on calculations of time and identify with clarity time periods and due dates. There's a section in the study guide that explores this in more detail, but remember that it's not just contracts that require time periods and due dates being defined clearly. It also might be necessary in things such as trust deeds, where trustees have to do things within particular timeframes, and partnership agreements, etc. So it's important to turn your mind to calculations of time and then work out what the appropriate wording should be depending on what your client says.
Lists can be a really useful tool when trying to draft clear and precise provisions. However, they can also cause ambiguity where they're complex, and they can also feature as examples of bad drafting because the header that introduces the list does not flow into the content in the list. An example is provided on the slide there. So that first example, you can see it says legal drafting is fun, and then item 1 says because I'm learning how to be a lawyer, and then item 2 says has easy assessment. If we removed item 1 from the list entirely, the sentence does not make sense. So legal drafting is fun, has easy assessment just doesn't make sense. What we therefore need to do is ensure that the header can flow into a sentence with each item in the list on its own. And the second example on the slide there is an example of a list that works well. By putting legal drafting is fun because, and adding then 1, I'm learning how to be a lawyer, and 2, it has easy assessment, what we have is a full sentence for item 1 on its own and a full sentence for item 2 on its own. So you must pay attention to detail when drafting lists. The header must make sense when it's viewed in isolation with each individual item in the list. Now, this kind of drafting error doesn't necessarily affect the way that the contract or relevant document is read, but it does look unprofessional. Sometimes it can create a great deal of ambiguity and be problematic for your client. So it's really important to pay attention to lists. There's more on lists in the study guide and the reading this week, so make sure you check those out before the workshop.
Now, here, the key principle is to draft according to the purpose, context, and reader. But plain English drafting goes beyond that. It looks at concise drafting principles, looks at the use of legalese, and tries to reduce our reliance on legal terminology. So let's go into some of those details now. So the first thing I'd like to focus on is concise drafting. Long gone are the days of long-winded sentences. Lawyers used to be paid by the word, so it makes sense that documents were as long as humanly possible. But now we strive for concise drafting, clear and precise drafting that is expressed in a concise manner. So whenever drafting, stick to the motto, keep it simple. Now, there are a variety of phrases that you use every day that can be reduced to a single word. So, for example, I might say, with reference to X, really what that means is just regarding X or concerning X. So, plain English drafting tells us that we should use that latter one word to symbolize what we're trying to say. So, we'd start the sentence by saying regarding X. Another example is as a consequence of. We quite frequently say that when we're speaking. We quite frequently type it because we think it looks professional. But lawyers strive now for expressing content as simply and concisely as possible. Another thing to be mindful of is the use of superfluous words like hereinbefore, hereinafter, aforementioned, aforesaid, herewith. All of those phrases don't actually add anything to a sentence, so avoid their usage wherever possible. You'll find that they still pop up in the odd precedent. There are also a range of phrases, as well as just singular words, there's a range of phrases that don't really add anything either, like the parties hereby covenant and agree. Really just means the parties agree. So again, look out for those when you're reading older documents and precedents. Now, specialist legal terms are a tricky area. You really need to consider your audience here. Is it acceptable to use the phrase in personam when you're writing to another lawyer? Yes, it's acceptable, although in many cases a plain English equivalent does the job just as well. But it's important to use the plain English equivalent when you're writing to a client who will have no idea what that means and will be thoroughly confused. So when you're referring to legal terminology, when you're using legal terms and phrases, make sure that you have the reader in mind at all times. Moving on to looking at the difference between the active voice and the passive voice, plain English drafting principles say that we should use the active voice wherever possible. So look at the two examples on the slide and try to identify which one is expressed in the passive voice and which one is in the active voice. Pause the video if you need to. So the first example on the slide is an example of a sentence expressed in the passive voice. Here we have filed, which is the verb. The plaintiff is the subject because the plaintiff is the person filing the application, and the application is the object. That's the thing that's being filed. Here, the application comes first in the sentence, which means that the object appears first, then we have the verb, and then we have the subject. So that is expressed in the passive voice. So too is the sentence that follows, it was served on the defendant by the plaintiff this afternoon. In that sentence, the plaintiff is the subject, the verb is served, and the object is it, because it's the application that's being served. So here we've got it comes first, so the object is first, then it's verb, and then it's subject. Again, that's expressed in the passive voice. So if you look at this second example on the slide, that is an example of how those two sentences in example 1 can be rewritten to be expressed in the active voice. In this instance, both of those sentences within example 2 follow the subject, verb, object requirements. Now, why is this important? It's important because, of course, it makes the sentence longer and more difficult to work out. The reader has to wait till the end of the sentence to identify who is doing the action. Sometimes the use of the passive voice is unavoidable, where the person who is doing the particular thing, i.e. the verb, is unknown. So take, for example, a situation where someone comes home from work and finds that someone has broken into their house and stolen several items. You can see on the slide there, the witness might say, when I went into the media room, I saw that the television had been stolen. Now, to steal, stolen is the verb in this situation. What's stolen? It's the TV. So that is actually the object. Usually you would identify the person, the subject of the sentence, who is stealing the relevant item, but because that person is unknown, then that person doesn't appear in the sentence. So this is perfectly fine, but where the subject is known, then you want to avoid the use of the passive voice, because sometimes it can disguise who the subject is or not even mention them at all. Moving on to gender neutral and non-discriminatory language. You may find when you're reading older statutes that traditional drafting is still employed in those texts and they haven't been amended to correspond with contemporary drafting practices. So, for example, you may find that a statute only refers to the masculine. So, for example, if it's talking about an individual and what conduct that individual may do that amounts to an offence, it would only use he, him, and his when talking about the individual. That's archaic and should most definitely be avoided in your drafting. In such circumstances, you need to either use he or she, and of course the equivalents of his or her and him or her, depending on the context. Or alternatively, use they, and of course their and them. They is now the preferred way because it's more inclusive. You should also try and avoid stereotypes when drafting. You can see on the slide there the example of cleaning lady. Instead, you should use cleaner. What we're doing when we use things like cleaning lady is we're stereotyping and we're placing women usually in lower paid, lower skilled roles and males in positions of authority or higher paid roles. So sometimes we will see people refer to professor, doctor and judge as male even when they don't know the gender of the relevant person. And we see the reverse with childcare workers, cleaners and nurses. They tend to be assumed to be female. Where you don't know the gender of the relevant individual, it's better to use they, their and them, or alternatively he or she, his or her, him or her. There are a whole range of terms that adopt stereotypes and appear to be discriminatory when we look at them, so have a look at effective legal writing for more examples. It's important at all times to use inclusive language. An example is where you say X is disabled. Instead, say X has a disability. Why is that very small difference in expression important? Well, it means that we are not defining the individual by reference to that characteristic. And in a similar way, we should use respectful and culturally appropriate language. So, for example, when you're talking about Indigenous Australians, you should always use a capital I, which is a mark of respect. And you should also avoid using acronyms or slang that define groups or cultures or particular characteristics, because this can be taken by the reader to be both unprofessional and disrespectful. As effective legal writing explains, consistency in drafting is essential. Failure to be consistent may confuse the reader, and it can also lead to ambiguity in the interpretation of the document. So, for example, you should be consistent with your use of terms. Definitions can be very helpful, particularly in large documents. They can declutter the document and they can provide certainty as to what a word or a phrase means. However, if you're going to use definitions, make sure that you use that word consistently throughout. If suddenly a different word appears, the reader might assume that you meant something new. You're introducing a new term at this stage. Consistency of tone is also important. Now, the tone will be dictated by your client's instructions or the context, such as whether you are responding to allegations made in a letter you have received, or you're offering to settle the dispute in a letter to your opponent, and that will determine the tone. But you must make sure that you're consistent with that tone throughout the document to ensure that it has maximum effect. Grammatical consistency is also important, in particular in relation to the tense that you are using in that document. Issues with grammar look unprofessional, but they can also cause confusion in the reader. So make sure that your tense is consistent throughout, such as if you're speaking in the present tense about something in particular, such as your offer to settle, then make sure you maintain that tense for the whole of that aspect of the discussion. Consistency in presentation is also important. So your margins, whether you justify the text on the left or you fully justify it, your line spacing, the font that you use, the size of the font, and your paragraph numbering must all be consistent throughout the document. Things such as how you present the headings, whether you are putting them in bold or underlining them, whether they are larger than the text in the rest of the document, is also important. Your headings should be consistent. So if you have a primary heading and you use that in 3 places, that should all look consistent, and then your subheadings should be different to the primary heading, but they should all be consistent as well. Again, this is necessary to ensure that the document looks professional and to avoid confusion. Now, of course, if you're in legal practice and you're preparing a particular document and there's a practice direction about what format it should adopt, then you must, of course, ensure that your document is formatted in accordance with those requirements. The same is true if you have task instructions at law school that are quite specific about the format. Make sure that your formatting is consistent at all times. But if you don't have specific requirements, we recommend that you use a professional looking font like Times New Roman, Arial or Calibri, and that you use 12-point font size. And the reason we say that size of text is because it's very difficult for the reader to absorb information where the font size is smaller than that, and particularly when it's on a screen. So it's a really good idea to have 12 as the minimum. Use 1.5 line spacing and a decent margin on either side of the page to allow for some white space on the page, so that the words and lines don't just blur into each other when we look at the document on an A4 piece of paper or look at the document on a screen. The information can appear quite crammed, and it can be difficult to follow the sentence across several lines if it's small, densely packed in, and there's not enough white space on that page. Remember also that paragraphs symbolize that you're moving on to a new point or a related point, so make sure that you stick to 1 point per paragraph, and remember that headings flag to the reader what will follow, so your heading should very much symbolize what is about to follow in the subsequent paragraph. Note that it's not just the fact that headings flag to the reader what will follow that makes them really helpful in legal practice. If you've got a time-poor reader like a judge or an opponent, they can find what they need in a hurry. They can hone in on a particular aspect of the document and don't have to read it from start to end. Note that we are barely skimming the surface here of all of the drafting principles that are going to be relevant to you when drafting legal documents. Next week, we will be focusing on grammar, and although you may feel like you're a grammar expert, it's still important that we go through that material to make sure that we are not making grammatical mistakes, which subsequently give rise to interpretation issues and end up being costly mistakes to our client. So that's it for this week. Make sure you have a look at the study guide and the reading in detail, and I'll see you in the workshop.